Good afternoon, aspirants. Greetings from Sadik IAS Academy. I hope every one of you would have successfully completed your preliminary examination. So now is not the time to worry about the exam results. So you have done your part. So let us all just hope for the best. So we'll just try to solve today's question paper with respect to polity and its related current affairs. So what was the nature of today's paper was that I would classify the difficulty level of today's paper with respect to polity between easy and moderate, because some questions were 2 or 3 questions were a bit difficult and out of the scope of our syllabus, and more questions were directly asked. I mean, more questions were direct questions. So we'll just try to solve today's polity questions. So question number 11 in set A of today's question paper. So consider the following statements. Statement number 1, pursuant to the report of H.N. Sanyal Committee, the Contempt of Courts Act 1971 was passed. This statement was right, because H.N. Sanyal Committee was constituted in 1963, and based on the recommendations of this particular committee, the Contempt of Courts Act 1971 was passed. Therefore, the statement 1 is right. Statement 2, the Constitution of India empowers the Supreme Court and the High Courts to punish for contempt of themselves. This statement is true. So Constitution of India empowers the Supreme Court through Article 129, and it empowers the High Courts through Article 215 to punish for contempt. So therefore statement 2 is also right. What about statement number 3? The Constitution of India defines civil contempt and criminal contempt. This statement is wrong, because Constitution of India does not make any distinction, or nor does it provide a definition. So the definition for civil contempt and criminal contempt is provided in the Contempt of Courts Act 1971. Therefore the statement number 3 is wrong. So what about the 4th statement? In India, the Parliament is vested with the powers to make laws on contempt of court. This statement is true. So Article 29 empowers the Parliament only to make regulations with respect to contempt powers of the Supreme Court, whereas it cannot curtail the powers of the Supreme Court with respect to contempt. So therefore the right answer is B, 1, 2 and 4. Because we have eliminated statement number 3, we could have easily derived the answer, which is option B. So the 12th question. With reference to India, consider the following statements. Statement number 1, government law officers and legal firms are recognized as advocates, but corporate lawyers and patent attorneys are excluded from recognition as advocates. So this particular question is from this particular act. So the Advocates Act 1973. So both these statements are from this particular legislation, and both these statements are right. So statement number 2, bar councils have the power to lay down the rules relating to legal education and recognition of law colleges. This statement is also true. So this particular question was a bit difficult question, because without knowing these technical stuff, we won't be in a position to handle this particular question. So the right answer for this particular question is answer C, both 1 and 2. Yeah, we'll move on to the next question. Consider the following statements. Statement 1, a bill amending the constitution requires a prior recommendation of the President of India. So this particular question deals with Article 368, amendment of the Constitution. So statement 1 is wrong, because there is no such provision in Article 368. What about statement number 2? When a constitution amendment bill is presented to the President of India, it is obligatory for the President of India to give his or her assent. This statement is true, because after 24th Amendment 1971, President is supposed to give President is mandatorily supposed to give his assent to constitutional amendment bills. So therefore statement number 2 is right. It is obligatory. Statement number 3, a constitution amendment bill must be passed by both the Lok Sabha and the Rajya Sabha by a special majority, and there is no provision for joint sitting, this statement is also true. Therefore, without statement 1, the option is statement option B, which is 2 and 3. So, this is the right answer for this particular question. So, moving on to the next question, 14th. Consider the following statements. Statement number 1. The Constitution of India classifies the ministers into 4 ranks, namely Cabinet Minister, Minister of State with independent charge, Minister of State and Deputy Minister. This statement is wrong. This statement is wrong because Constitution of India does not make or provide for any classification of the Council of Ministers. So, Article 75, which deals with ministers, only says that the Prime Minister shall be appointed by the President and other ministers shall be appointed by the President on the recommendation of the Prime Minister. So, that's it. So, Constitution of India does not make any classification like this. So, statement number 1 is wrong. What about statement number 2? The total number of ministers in the Union government, including the Prime Minister, shall not exceed 15% of the total number of members in the Lok Sabha. This statement is also wrong because as per 91st Amendment 2003, the maximum size of the Central Council of Ministers is 15% of the total strength of the Lok Sabha and not the total numbers, total members on the Lok Sabha. It is actually total strength of the Lok Sabha. Therefore, statement 2 is also wrong. The right answer for this particular question is option D, which is neither 1 nor 2. So, this is the answer. We will move on to the next question. Which of the following is or are the exclusive powers of Lok Sabha? So, statement number 1, to ratify the declaration of emergency. This statement is wrong because declaration of emergency under Article 352, Parliament requires the approval of the Parliament. So, Parliament is also including Rajya Sabha, right? So, it is not the exclusive power of Lok Sabha. Therefore, statement 1 is wrong. What about statement number 2? To pass a motion of no confidence against the Council of Ministers. This statement is right. This statement is right because it is the exclusive privilege of the Lok Sabha or the lower house. What about this statement number 3? To impeach the President of India. So, Article 61 provides for impeachment of the President by the Parliament. By Parliament. So, Parliament is inclusive of Rajya Sabha. Therefore, statement 3 is wrong. The right answer is option 2 only for this particular question. So, the exclusive exclusive power of Lok Sabha is nothing but to pass a motion of no confidence against the Council of Ministers. Therefore, the right option is, the right answer is option B. So, we will move on to the next question. With reference to anti-defection law in India, consider the following statements. Statement number 1. The law specifies that a nominated legislator cannot join any political party within 6 months of being appointed to the House. This statement is wrong because he can actually join. It's not like he cannot join. He can join within 6 months. Only if he joins a political party after 6 months, he will be subject to disqualification under this particular law. So, what about statement number 2? The law does not provide any time frame within which the presiding officer has to decide a defection case. This statement is true. So, this particular law does not provide for a particular time frame within which the presiding officer has to act. So, this is a major criticism for this particular law. So, therefore, statement number 2 is right. The right answer is, therefore, if statement 1 is wrong, therefore, the right answer is option B, 2 only. So, this is the answer for this question. 17th question. Consider the following statements. Attorney General of India and Solicitor General of India are the only officers of the government who are allowed to participate in the meetings of the Parliament of India. This statement is wrong because under Article 76 it only provides for the role of position of Attorney General, and under Article 88 Constitution empowers or gives the exclusive right to Attorney General to participate in the meetings of Parliament with respect to Parliament. So the relevant constitutional articles are Article 76 and Article 88. Therefore, statement 1 is wrong. What about statement number 2? According to Constitution of India, the Attorney General of India submits his resignation when the government which appointed him resigns. This statement is also wrong because this provision is not provided in the Constitution of India. There is no such provision in the Constitution of India, whereas this is just a convention. So when the ruling party, because the ruling party appoints him, so when the ruling party gives its resignation, naturally the Attorney General, because he is appointed by the ruling party, naturally he also resigns. Therefore, statement 2 is wrong because this provision is not provided in the Constitution of India. Therefore, the right answer here is neither 1 nor 2. The right answer is option D, neither 1 nor 2. So the 18th question. With reference to the writs issued by the courts in Indian Constitution, consider the following statements. Statement number 1. Mandamus will not lie against a private organization unless it's interested with a public duty. This statement is true. This statement is true. What about the second statement? Mandamus will not lie against a company even though it may be a government company. This statement is wrong because mandamus as a writ can be issued against any public body or a public person. Therefore, statement number 2 is wrong. What about statement number 3? Any public-minded person can be petitioner. Can be a petitioner to move the court to obtain the writ of quo warranto. This statement is also right. Therefore, the right answer is option C, which is one and 3 only. So this is the right answer for this particular question. So this is a current affairs based question with respect to governance in India. So 19th question, with reference to Ayushman Bharat digital mission, consider the following statements. Statement 1, private. This is a direct question which is provided exclusively in the website. So statement number 1, private and public hospitals must adopt it. This is right. It aims to achieve universal health coverage. This statement is also right. It has seamless portability across the country. This statement is also right. Therefore, the right answer is option D, 1, 2 and 3. Yeah, we'll move on to the next question. With reference to the Deputy Speaker of Lok Sabha, consider the following statements. Statement number 1. As per the rules of procedure and conduct of business in the Lok Sabha, the election of Deputy Speaker shall be held on such a date as the Speaker may fix. This statement is true. This statement is true. What about statement number 2? There is a mandatory provision that the election of a candidate as Deputy Speaker of Lok Sabha shall be from either the principal opposition party or the ruling party. This statement is wrong because since the 11th Lok Sabha, there evolved a parliamentary convention that the office, the position of speaker will be coming from the ruling party, and the office of the deputy speaker will be unanimously be coming from the opposition party. Therefore, this particular provision is wrong, because it says that the office of deputy speaker will come from either the opposition party or the ruling party. Therefore, this statement is wrong. What about statement number 3? The deputy speaker has the same power as of the speaker when presiding over the sitting of the house, and no appeal lies against his ruling. This statement is also true, because when the office of speaker is performed by deputy speaker, he enjoys all the powers of the speaker. That statement is true. So what about the 4th one? The well-established parliamentary practice regarding the appointment of deputy speaker is that the motion is moved by the speaker and duly seconded by the prime minister. There is no such provision. There is no such provision in the constitution. Therefore, the right answer is 1 and 3 only. One and 3 only is the right answer. Yeah, this is a current affairs based question with respect to governance in India. So 71, in India, which one of the following compiles information on industrial disputes, closures, retrenchments and layoffs in factories? So the right answer is Labor Bureau, Ministry of Labor. Ministry of Labor and Employment. So this is the right answer for this particular question. Again, this is a direct question. So current affairs based question with respect to governance in India. So in India, what is the role of the Coal Controller Organization? Statement number 1. CCO is the major source of coal statistics in Government of India. This statement is true. It monitors the progress of development of captive coal or lignite blocks. This statement is also true. It hears any objection to the government's notification relating to the acquisition of coal bearing states. This statement is also true. 4th statement, it ensures that coal mining companies deliver the coal to end users in prescribed time. This statement is wrong. So this is not a mandate or function of the Coal Controller Organization. Therefore, the right answer is option A, 1, 2 and 3. Yeah, so we'll move on to the next question. If a particular area is brought under the 5th schedule of the Constitution of India, which one of the following statements best reflects the consequence of it? Option A, this would prevent the transfer of land of tribal people to non-tribal people. So B, this would create a local self-governing body in that area. C, this would convert that area into a union territory. D, the state having such areas would be declared as a special category state. The right answer for this particular question is this. So as per provisions in the 5th schedule of the Constitution, Article 244, Governor is empowered. So Article 244 authorizes Governor to make rules for peace and good governance or good government. So option A is the right answer. Consider the following statement. Next question. Moving on to the next question. Consider the following statements. Statement number 1. Indian Sanitation Coalition is a platform to promote sustainable sanitation and is funded by the Government of India and World Health Organization. This statement is wrong because this is a civil society initiative. So there is no role of funding by the Government of India and World Health Organization. So therefore statement 1 is wrong. What about statement number 2? The National Institute of Urban Affairs is an apex body of the Ministry of Housing and Urban Affairs in Government of India and provides innovative solutions to address the challenges of urban India. This statement is right. this statement is right. National Institute of Urban Affairs comes under Ministry of Housing and Urban Affairs. This statement is true. Therefore, the right answer is option B, 2 only. The right answer is option B, 2 only. Moving on to the next question. With reference to the tea board in India, consider the following statements. Statement number 1, the tea board is a statutory body. So, because this statement is right. So, the relevant act is Tea Act 1953. So, the question starts from here actually. The tea board is a statutory body. This statement is right. Statement number 2, it is a regulatory body attached to the Ministry of Agriculture and Farmers Welfare. This statement is wrong because it comes under the Ministry of Commerce. So, statement 2 is wrong. What about statement number 3? The tea board's head office is situated in Bengaluru. This statement is also wrong because the head office is situated in Kolkata. So, statement 3 is also wrong. What about statement 4? The board has overseas office in Dubai and Moscow. This statement is right. This statement is right. Therefore, the right answer is statement 1 and 4. Option is D. The option 1 and 4. So, this is the right answer for this particular question. So, I believe these are some of the questions asked in today's paper with respect to polity and governance. So, all the very best. Do not worry about the results. You have done your best. So, let us all just hope for the best. Thank you so much.